Onun ismini verdim. And also, last reminder for tomorrow's program. Program starts from 2, and the number of seats reserved for a High Court Bar Association is 60. If it is more than that, no problem, but it should not be left unfilled. So it should be filled, and all the members are requested to attend with formal dress. And if anybody wants to wear traditional, also you can wear it. Scarf, all these are the edit decorations in your dress. And the thing is, we have got this person. Yeah. Yes. Thank you. Because the three of us go to the meetings there. So I didn't want to see. Enough. Number of the processor of processor of milk to is closer than 10,000 rupees because what is the possible instead of processing, she is closer. I like it's in view of tomorrow's program, I am busy going in the time really must be Is it okay? Maybe punishing us the whole day.
Number 8 hearing. Item number 8
Item number 3.
hearing, Lordship. Item number 8.
Yes.
I'm going to petitioner here, Lordship.
Hmm.
I have personal difficulties today. So I beg your Lordship accommodation for 2-3 days. Let the minimum be listed next week, Lordship.
Your Lordship, next week I'll have difficulties. So after 2 weeks, Your Lordship, and a date may be fixed, Your Lordship. On
Lordship.
29th, Your Lordship.
What is the matter about?
Lordship, family pension. Family pension. Non-settlement of family pension, Lordship.
Hmm?
Non-settlement of family pension.
So you should do it. 3 years have gone by.
Lordship.
3 years have gone by.
Yes, Lordship.
Then
Because, Lordship, several direction has been issued by this court to respondents to file affidavit after affidavits. That is how the matter has been delayed.
they have not filed the affidavit. Good for you. You don't have an
They
opposition.
filed 5 affidavits, Lordship. Now it is ready for hearing.
So we take it up.
I have some personal difficulties, Lordship. Next week, Lordship.
No, next.
Tuesday.
It will come up after 6 months.
No, Lordship.
After 6 months. Fix a date. November.
No, actually, what happened, Lordship?
Let
I'm
the
really
weather
pardon,
cool
Lordship.
down. Let the weather cool down.
I have some injury in my back. That is how I need some time, Lordship.
So you take it after
No
6
other reason,
months.
Lordship.
November.
Next week, Lordship.
3rd of November.
Next week, Lordship.
No. If you're not interested in doing it,
No, it is
so
not
after all, a
it's not the
family
question of
pension matter. No,
interest,
Mr.
Lordship.
Counsel. If you are entitled to, you should get it immediately. Family pension is a thing which is not
No,
a
Lordship,
bounty
the
of the
problem
state.
is, Lordship, today I'm having my physical problem, Lordship, due to back injury. So 2-3 days accommodation, Lordship.
Maybe after 2 weeks, my lord, if my lord may kindly accommodate.
It has been submitted on behalf of the learned counsel for the petitioner that the matter requires to be adjourned. First, the matter is a family pension matter. First, taking into account that the petitioner is not inclined to do the matter today, the registry shall list the matter when both the parties agree and file an application before the registry that the matter is required to be listed for hearing. First, it is observed that upon such application being filed and the matter being listed, no further adjournments should be granted.
Lordship.
Always.
For admission, item number 13.
May I please, your lordship.
Yes, what did you come up?
As you are aware, when we take up some case, we are confined to, in a very narrow area. And as far as the court is concerned, the vision is broader. The vision is broader to do justice. And because of that, I've been thinking, but then I have not been able to get any new thing to assist the court, except to agree to the court that the revival of CA3 2004. Now, in that, if that is to be revived, now whether it should be in the court of civil judge junior or towards the executive.
The problem which I'm thinking is that you see the Rule 31 does not mention anything, this is judicial or anything. It only mentions Deputy Commissioner or his assistant.
Deputy Commissioner includes ADC judicial
No,
as
no.
per the
The
definition.
Rule 31 does not specify
No.
DC
31 did
judicial
not
or
specify that
assistant
one.
to the DC judicial.
No, not mentioned.
It only mentioned DC.
Yes. Or
And,
assistant to DC.
and the basic idea on which it is being given and the first manner, there are two manners in which the DC can adjudicate. First, he may confirm it as his own, or he may go for a de novo trial if he doubts the decision.
Yes.
So therefore, the question is, when he confirms it is his own, he sticks to the customary law and the practice which is being done in terms of 26. That means there is no requirement of any pleadings or anything is required, nothing is required. He will only look into it, okay, this is fine with this thing and I confirm it as my own. So there till then, the customary law by which the adjudication has been done is being carried out.
Yes.
But the moment he goes for a de novo trial and doubts the decision, it comes that he exercises his judicial powers.
Yes.
And if this is a judicial powers and then there is a separation of the judiciary with the executive now, don't you think that it would be better that it is now laid before the judicial courts which have the authority?
Your Lordship, that clarification I would like to hear, so that's okay.
So I think
That's
that is
better.
I think that would be the proper thing.
Yes.
The moment till he exercises the jurisdiction as his own and confirms it, it is in the path of a customary law by which it is being done.
Yes.
The moment he thinks that this is not proper,
Yes.
and he will go for a de novo trial, the word trial is being used, which is not there in 26. Neither the Dobashi court or any other court is going to have a trial. The trial is being used out here for a de novo trial, which will require framing of issues and all these things. Then I think taking into account the separation of the judiciary, it would be better if it is filed before here.
Yes. That's it.
Yes, Mr. Siti Jamil, you are the president of the bar. What do you think? Because this has a lot of ramifications.
The other matter which is pending.
Yeah. Still pending.
Still pending.
Yeah.
Now that is pending because if you see the judgment of the Supreme Court in the case of Union Territory of Ladakh, Jammu and Kashmir and Ladakh versus National Conference, that's a judgment by Justice Vikram Badnath. The question arose out there as to whether the high courts should not exercise its jurisdiction when there is a reference pending before the Constitution bench or there is a matter pending before the Supreme Court. The Supreme Court said no, they are to go ahead. So the question of there being a reference out there is another aspect. But the question here is the bridging of the gap. How do you bridge it? How do you connect when and which is the point to connect with the executive judiciary?
In view of separation of judiciary from executive, that consequences which your lordship has proposed, but we have to follow.
No, I am not proposing. I am only saying that whether it would be proper. Because there, one aspect which I feel, till the district, the deputy commissioner takes it as his own, he is exercising the jurisdiction which is there in the customary law.
Yes.
He does not touch anything. As per the
Yes.
customary law, he follows.
Yes.
But the moment he doubts the decision and says that there should be a de novo trial, and I don't think trial is being used out there in the other cases and before the other authorities. So when he says about the trial and then he has to go, then there will be requirement of framing of issues.
Yes.
And in view of the separation, it would be better
It
in
will be
that.
a proper trial.
Has to be a proper trial.
Yes.
Then I'll do one thing, anything else? Did you see that Arunachal Pradesh Civil Courts Act? How does they treat this? They also have a similar one in 30 or something.
Yes, they have mentioned.
This is how they have also done it.
Yes.
Because what has happened here, kindly come to
Page 4. Page 4. para 3. So para 30,
Appeals, 15.
yes,
Appeals from decree or order passed by the court of district or session judge, it will go into the appeals from decree or orders by the civil court so and so shall lie to the court of the district judge, and where a court exists to the or to the high court as the case may be. Now kindly come to appeals from decrees or orders passed by the civil court junior division in so and so.
last paragraph of Rule 15. Section
Provided that any appeal on civil suit pending before the court of the deputy commissioner shall be disposed of by the concerned deputy commissioners under the provisions of the Assam Frontier Regulation as expeditiously as possible, but not later than 1 year from the date of coming into force of the act. Provided further that from the date of commencement, and in case an appeal is preferred against the judgment of a customary court in the court of the district judge or the court of the edition as the case may be, the court of the day may dispose of the same or proceed with the case de novo.
Yes,
So this is how they have put it.
yes,
So the moment they go for a de novo, it will be as if a fresh trial.
yes,
It will be a trial. Or so here another aspect which is given by the legislature is after the coming into effect of this act, there cannot be a filing of an appeal before the deputy commissioner.
yes,
This is what has been done here.
submission.
Yeah, but another, the first proviso says, and thereby it says that all the appeals which are there before the district deputy commissioner has to be disposed of within 1 year.
Yes,
And if it is not disposed of, then it has to come before the district judge because the jurisdiction is lost by the deputy commissioner
Yes.
after 1 year. Because they still maintain the customary courts. You see this? And we come to 2D. Customary court means the court of traditional council or authority of a village indigenous to the state by whatever name called, and includes a court of the village authority under section 5. So they still maintain the customary courts. Then if you see further, again in number 10, the proviso, provided that the court of the deputy commissioner existing under so-and-so in relation to the administration of civil justice prior to the commencement of the act shall be deemed to be the court of the district judge. Under this act, in respect of appeals that lie from the customary court until such time the said appeals are disposed of, the courts of the extent so-and-so, commencement on there shall be deemed to be the court of the civil judge in respect to this. Now, what has happened out here, although we don't have a legislation to that effect, by way of a notification, they have made this DC judicial to the district judge.
yes,
That is the main problem which arises. Although the rule 31 has not been amended to have DC judicial. Does rule,
suppose if in the definition, if DC includes ADC judicial,
there is no definition to that effect.
in the rules it is there.
Okay?
Page one definitions, 1C.
Except where the contrary appears from the
B and
context
C.
includes additional data as the
B.
case may be, and also includes officers designated as deputy commissioner judicial. So if this be so, then we can read 31 as DC judicial.
Yes,
So, but as of now, you don't have DC judicial.
They have been designated as district and session judge.
Understood.
Yes.
So if that be so, if they are saying, if we are to decide, say that the deceased judicial or the assistant or his assistant
Yeah.
means the deceased judicial,
Yes.
deceased judicial means the district judge.
Yes.
So can an appeal now be filed before the deceased judicial, the district judge from the customary court?
That is, that will be an issue which may be decided in the taken care of by the, in the reference matter.
Now, when did
Because
this
there is-
amendment happen? One
in
C, when did they
2003.
bring the DC judicial? DC means the DC judicial. These definitions were brought in by the 1984
Yes.
and it received the assent of the president.
Yes.
Now, but this 31, as per the 87, 84 amendment, is actually required to be repealed,
Yes.
but it has not been given
It has not
effect.
been. It has been
And there
restored.
the problem therefore arises.
Yes.
Now, in view of the definition which have been accepted in section 1(2), 1(2), I suppose, no?
1B.
1B. And this already having come in, then this deputy commissioner would mean the deputy commissioner that one. This is judicial also.
Yes, that includes this is judicial.
This would mean that this is judicial.
Yes. Now, when the nomenclature was changed in 2008, the post of DC judicial, it was not there. But in anticipation that sometimes it may be better. They have given the DC judicial as district and session judge.
No, when was the post of DC judicial created?
Creation of DC judicial, the leadership, I'm not aware.
And when did that notification come in? You have that notification by which this change happened, na?
2008. Existing judicial post, that means the creation of, the time of creation, I don't know, but it is in existing.
But this is an amendment insofar as only the Nagaland Judicial Service is concerned.
Yes. Yes,
But there is no corresponding amendment to that in this act.
no,
And when was the post of DC Judicial created?
creation time to, I'm not aware. But as per this notification, the existing judicial post, it says. So it must have been existing.
That
Though
must be
no one
existing
might
somewhere.
have been appointed against that post. Because at that point of time in 2008, there is no DC judicial, as no one has been appointed as DC judicial except a DC judicial. But this notification says that even this post is existing.
Where can we get the Nagaland Judicial Service rule? Because this must have been, because this is of 2008
Yes.
and Nagaland Judicial Service rules is of 2006.
2006.
So prior to that,
Prior to that,
there was no DC
they don't
Judicial.
have, they don't have separate service rules. Separate judicial service rules.
How were they regulated? Because what happened, the problem here arises in 2004. Here the problem happened in 2004 because 16/8/2004 is the order. The GB order is of 16/8/2004. You filed an appeal then.
Yes.
So was there DC Judicial then?
We approached the assistant to DC.
Whatever may be, whether assistant to the DC Judicial was there,
Yes,
then
it is there. A DC judicial also was there. And magistrate first class, second class, they are also appointed as assistant to DC.
where is the appeal memo? You have a copy of it?
Yes,
Assistant to Judicial, DC. This is the order. Assistant to DC.
yes.
You have a copy of the appeal memo? Yes.
Yes.
So it was just filed as an assistant to DC,
Your Lordship,
not assistant to DC Judicial.
no.
The younger Iralu, kindly give me a photocopy of this. Okay. Let's do one thing. Let me do a CAV, reserve it,
Your Lordship.
give a thought to it, what is to be done. Because I have also delivered one judgment in the context of Rule 15 in Section 15 of in the Arunachal also. There the issue also arose to that effect as to how it is to be decided by the district judge. The question arose means the district judge, you see the words out here in the second proviso to Section 15. It says the court will decide or go for de novo. If you see that, because I have given an interpretation on this, the second proviso, provided further that from the date of commencement, in case an appeal is preferred against the judgment of the customary court in the court of the district judge, or in as the case may be, the court of the district judge or the court of the additional may dispose of the same or proceed with the case de novo. So this aspect, how it is to be done, I have dealt with in that judgment. It is reported also. Let me have a look at that. And okay. And you kindly give me those two judgments of Justice Sarto, wherein he says that the appeal will lie before so and so, and one by Justice Chaudhary, which is now being referred there. Have a look at that also.
One is told by.
Yes, one by Justice Sarto also.
No, just give me.
Looks like.
Okay. Give me the three judgments also. During the course of the day, if you can give it to anybody.
After
The hearing completed. Heard Mr. R. Iralu, the learned senior counsel, assisted by Mr. L. Iralu. The learned counsel appearing on behalf of the petitioner, and Mr. So-and-so, who appears on behalf of the respondent. System hearing completed, judgment reserved.
Lordship.
The order will be the same, which I said.
Yeah.
Reinstating, bringing back civil appeal.
Your Lordship.
Now, the only question is where to file. That will be the only thing
Yes,
for which,
because question of pecuniary jurisdiction may also be there, junior and senior.
huh? Because then the question will arise. Now, does the rules out here say anything about pecuniary jurisdiction? No. It only says about to the DC or to his assistant.
They have not mentioned anything.
Right. So then in that case, can a assistant to the DC, if today the pecuniary jurisdiction is much more, or if it is more, because now the question will come up before the civil court junior division or the senior division. And you follow the Bengal Agra
yes.
Civil Courts Act.
Yes.
And if you follow it, I think it is still 20 or 2 lakhs. 2 lakhs is the junior division. So then the question will be where to file, because you have not till now mentioned about the writ. Then how do you do that then?
When the plane was filed by the present respondent, they valued it at 50,000.
Then it will be before the junior division.
Yes.
Now that is depends on you now.
Your Lordship. That will be a sort of what do you call it? Making the defendant as plaintiff I forgot the word.
The exact word, I'll give it to you. It is in order 1 rule 10,
Transposition.
transposition of the thing.
Another factor, Your Lordship, because since I'm supposed to be filing the plane, now the value, whether it should be at that point of time or at this point of time.
No, I think it will, the direction to file a de novo was then.
Yes.
So there was, I have to say that there was the wrong legal advice for which the plaintiff, he filed it.
Yeah, okay.
So this is how it will be. So that direction I have, therefore I'll put it at that point of time.
Your Lordship.
and revive the stay order. And once I revive, this order becomes ineffective because there is an existence of a stay.
Yes.
Okay.
Lordship, may I get a clarification from your lordship that if the matter, the appeal, civil appeal is to be restored, then in that case, a de novo will be reheard, or since the de novo has already been heard?
No, we will put
the-
it to, we restore it to the stage of the civil appeal 3,
Yes, lordship,
on which date the court decided to go for de novo,
lordship,
till that stage. Because thereafter the mistake happened, na? You
lordship,
filed it,
lordship.
which you should not have filed it.
Yes,
They should have filed it.
lordship.
Prior to that, there is nothing wrong. Because you have also agreed for a de novo.
Yes, lordship.
So at that point of time, there was nothing wrong at that point of time. So only problem happens after the de novo, you on mistaken advice have taken that.
Fine, yes.
So from that point, we have to put it on that very date. We restore it to that stage.
Then in that case, I will be permitted to file a written statement.
Oh, yes, definitely. Let him file. And if he doesn't file out there within, I'll put a date
Lordship,
that as it has gone de novo, he will file his suit. Or if I say it, that the suit, he has to file a suit within a particular period of time. And from that time, the law, CPC will follow.
very well, lordship.
You know what to do.
Pleasure.
Obliged, lordship.
Your Lordship, now earlier, the deal was registered as civil suit 1 of 2008. So we will maintain the same number.
No,
Different
it
number.
will be
On
now.
my filing.
It will be now only. The number will be now.
Okay.
Because now it will depend when, what is the jurisdiction you put.
Yes.
He may put 50,000 as his liking. You may put it 10 lakhs of your liking. You may think that, okay, from that appeal suit, the appeal should directly come to the High Court, not to any district court. Right?
Pleasure.
Lordship, regardless of whether the petitioner will file a suit or not, it will be considered as an appeal, right? Lordship?
The moment an appeal has gone for a de novo,
Yes.
then they will have to file a suit, not a
Lordship.
suit. That will, we will go for a trial. For the purpose of trial, there will be a requirement of a suit, a plaint. So he will file the plaint. Once he files the plaint, he will file a suit. So this suit now, in view of this, has to be numbered. If it is now before, because now with the separation of the judiciary, it cannot now, the judicial functions cannot be allowed to be done on the, with the executive. And when there is no ADC judicial or this is judicial now.
Lordship, my doubt is whether that will be considered as an appeal or not, then in that case.
No, that won't thereupon be an appeal. But he has to challenge that order of the GB
Yes.
in his suit and ask for his declaration of right title, whatever may be, whatever he may ask. I need not suggest much.
Lordship, I'm sure Lordship have already considered this aspect, but since the reason why I'm doubting this is that if it's converted into suit, then one day if I challenge that suit, then it will be before the district judge, second appeal. That will be second appeal. Now, if I'm to go for third appeal, then
Third appeal does not, there is no
does
third
not
appeal.
permit for a third appeal. So it ends at district judge in that case.
No, you see, it will all depend on his jurisdiction. Tomorrow, if he has put it jurisdiction below 2 lakhs, the first appeal will lie before the district judge.
Yes.
The second appeal will come before us. Now tomorrow, if he puts at 11 lakhs, then the first appeal may go before the district judge then also. If he puts it more than 20 lakhs in his suit, first appeal comes here.
Lordship.
Your Lordship, another aspect, just now it has first come out when we are mentioning about the GB's order. Now, I'm filing the claim. Now, Your Lordship says I'm to challenge the order of the GB's. Now, in the original plain or suit, can I challenge the decision of the GBs? And not by way of an appeal against the one.
No. You have to mention that as the court had directed for de novo trial, that is the requirement for you now to challenge here. You see, you have already filed an appeal. You have to mention it in your plaint, if you have, as you are filing a plaint, that you have filed an appeal. Court has directed you. The court has said that it will go for a de novo trial. And that is the requirement why you are now filing the plaint. And in that regard, you have to therefore say, declaration of your right, title, and interest. And that will be the declaratory relief under 34. Now, the consequential relief which you will be seeking is for setting aside this thing and for cancellation of this order and for other permanent injunction. I think I should not further say.
Also, pleasure.
Grateful, Lordship.
For motion from the supplementary cost list, item number 10 and 11.
Sir, finally the bridge is made.
Huh?
I'm telling, sir, finally the bridge is made.
Yes.
Where is lordship?
Was there anything, formation of an opinion?
Your Lordship, may I kindly see the page 2. Note that para second. The incident has happened, that line, my lord. My lord, here the incident has happened. May I read, my lord? Thereafter, in the second page, para 3, it is mentioned that in presence of witness available witnesses and also intimated has been given to the relatives of the accused person about the ground of the arrest.
Encloses annexure. Where is the annexure?
That is the arrest memo, my lord. Yes, yesterday I have produced before the court, my lord.
No, here you don't have the annexure.
Yes, ma'am.
No annexure.
No, yes.
No, here it
Yes.
says, now visited so-and-so village and reached the deceased house and conducted legal formalities. Okay,
Yes,
that is at 12:20.
yes,
On refusal to conduct postmortem by the family members of the victim at his residence, the refusal form of PM was duly signed and handing, and taking over of so-and-so was also done.
yes,
Now prepare proper arrest memo
yes,
of the two accused persons so-and-so in presence of available witness, and also intimation has been given to the relatives of the accused persons about the grounds of their arrest enclosed. Now self along it. Now where is the grounds?
my lord. Your lord, the next paragraph. No, the first page. Your lordship, may I kindly see the first page.
Then in the
Please.
meantime, one so-and-so visited the incident, the
No, my lord,
investigation is
first page. Your lordship, may I kindly see the first page.
first place.
City open, yes.
First place is which
The-
one? At
the-
11?
The one.
Huh? One.
The first page.
Okay.
The incident has happened on that line, your Honor.
After the was received at so-and-so, on which date so-and-so, the police also observe all legal form with regard to medical form and after legal test and injury from in the meantime, one person team of so-and-so, smart city at an extracted so-and-so, the investigating agency also took the initial statement of the victim's son about the incident. Later on, it is learned that the victim has succumbed to the acting so-and-so. Later on, an FIR has been filed and endorsed to me for further investigation. Again, by so-and-so. So where is the grounds?
No, my lord, see, your lordship, may I kindly see the first page. Let me explain, my lord.
Which,
There, the incident has happened on date. That is
I've
the,
read the entire thing.
yes, my lord, here that this is the facts.
No,
So this,
you see,
my lord,
why do you want him inside?
yes,
That is the grounds of arrest.
yes, my lord.
Where is it?
Let me explain, my lord. Here it says that that accused has been informed that he has been connected, he has been arrested in connection to incident happened on 8/5/2024.
Where?
That you not your,
And given to the relatives of the accused about the ground of the arrest. Where is
Yes.
the formulation of the grounds of arrest?
that's what I'm saying, my lord. Your lordship, kindly see the first page.
First up,
That
understood.
that incident that
No, you have to formulate.
this is the
You
formulation,
see,
my lord.
no,
My lord.
You see the in Vihan Kumar or whatever it may be.
Vihan Kumar.
Okay. You see it is the proposition which is similar to a case for PMLA and or Income Tax Act have been imported into Vihan Kumar. What happens is it is normally required to be written, given a writing to the person that these are the grounds on which we are arresting you. These are the grounds. And you don't arrest. Why do you arrest? You arrest somebody because he is required for the investigation.
Yes.
You arrest somebody because of the fact that these are required for his investigation, or if he is not arrested, there might be reason that he will tamper with the evidence. These are the grounds on which you arrest, isn't it? You don't arrest somebody because a commission of crime has happened. You are required, you arrest somebody because if you don't arrest him, you can't investigate. You need him for your interrogation. These are the grounds, isn't it?
Yes, my lord.
And my lord, see, the accused was informed that why he was arrested means he was arrested in connection to incident happened on 18/5/2024, and he has been booked under section.
That is what
so
Mr.
That was
No, Mr.
that-
From kindly
yes,
appreciate one thing.
yes.
I understand everything.
Yes.
But the problem arises is paragraph 15 and 18 of Vihan Kumar, which says that you are to maintain in the contemporaneous records the formulation. Where is that?
My lord, it is in the CD.
Not
This is
there.
the formulation. This is the paragraph which I'm mentioning, my lord. And my lord, in the reason,
Paragraph 1, 2, and 3, paragraph 1, 2, and 3 says about the incident,
yes,
the investigation carried out. But why is he required to be arrested?
my lord, that was explained in the page number 56 in the petition. It says that the reason has been already stated to prevent the accused person
From committing other crime.
yes,
That
from
cannot be
doing further-
that.
This is the reason, my lord. This
That is
also
the reason, if that is the ground of arrest, that is the ground of arrest to prevent him. That ground of arrest is absolutely incourageous. Cannot be a ground of arrest. Why do you arrest? You arrest him because it is required to get investigation. Upon searching this place, we now know that I've come to learn that this person is concerned. So you have to specify that yes, these are the grounds of arrest, why we are doing it. Or you have to formulate here. There is no formulation. And prevention that he will commit another crime. That is never the question. That was never at all the aspect. You have just put a tick mark in a cyclostelp, in a performer. You should have other reasons is there, na? Then down below there's other reasons. You should have put it out there and the reason why. That would have been successful. Yeah.
my lord, our only stand is we have formally, verbally informed the accused about the grounds of arrest.
Unless you formulate in contemporaneous records, how do you take
And-
care?
and
Read
as-
paragraph 18 of Vihan.
Yes, as per the record, this is the formulation, my lord. As per the CD, this is the formulation, my lord. So,
Only one thing good is, in Vihan Kumar, they did not go as to whether they can be subsequently arrested. That question is left open. Think about it. But the question in Vihan Kumar is, it says that the moment a person is, the arrest is illegal, there cannot be a remand. The remand becomes illegal and the continuation of the detention becomes illegal. That is the principle of Vihan Kumar. And
Yeah.
therefore he is entitled to bail.
so my lord, here, our studies, incident was happened on 18. FIR was received. So basing on that FIR, case was registered and that registered under the section so that it has been mentioned in the city. So basing on that, we have informed the accused that we are arresting in this connection of this case. That is the ground we have explained to the accused in presence of the witness.
Mr.
Yes.
Counsel, I also know you arrested him from the materials it appeared to protect them.
Yes.
To protect them, you have arrested. Otherwise, some untoward incident might happen against them. As would appear from the order which was passed by the magistrate in Woka. You should have brought him into Kohima. You did not. You took him to Woka. Woka, the reason why you have taken it, otherwise it would have lead to a law and order situation.
Yes, my lord.
That is the basic idea.
That is the reason.
That is actually the ground of arrest. But that cannot be a ground of arrest. That is the question of protection. The ground of arrest is required for the purpose of investigation purpose. There is no formulation. And to say that the ground of arrest is the reason of arrest, to say that it is to prevent that they will commit another crime, you have to have basis again that they have been doing other crimes also.
Lordship will appreciate that what your lordship is saying, that is the reasons of arrest. That has been very elaborately been discussed in Pavil Purkastas, where the Honorable Supreme Court says that reasons of arrest are in general. That is to prevent a commission of crime, anticipation that he may commit a crime. So that is reasons of arrest are in general, but the grounds of arrest of an accused person has to be specific, because it is specific, because like your lordship said, that
Where is that?
that is in Pavil Purkastas, para 20
Of
of the judgment.
which judgment?
Pavil Purkastas.
You have not given me.
I have,
You
lordship, I have quoted it extensively in the petition.
you are
also.
given. I don't look into the.
My lord, I'm giving. Your lordship will find
Where? Para 20 says something else.
Pavil Purkastas. Your lordship is there.
Yes.
I'm just. So. Lordship will find para 49.
See?
Para 49.
From para 29.
No, 49. Sorry, 49.
From para 20, we are running to para 59.
Sorry. Para 49. It may be repeated at the cost of repetition. There is a significant.
Para 49.
Para 49.
From the detailed analysis. Ruby
No.
Purkas, the para
Your lordship is Pavil Purkastas. This is your lordship. Yes, para 49.
Para 49, as I read from the detailed analysis made above, there is no hesitation.
No, my lord. My copy is different. It
So
will
you
be,
are giving me a different copy.
your lordship will. It will be para 48 then in your lordship.
Okay.
It may be repeated at the cost of repetition. That there is a significant difference in the phrase reasons for arrest and grounds of arrest. The reasons for arrest, as indicated in the arrest memo, are purely formal parameters raised to prevent the accused person from committing any further offense, for proper investigating of the offense, to prevent the accused from causing the evidence of the offense to disappear or tamper with such evidence in any manner,
to prevent the arrested person from making inducement, threat, or promise to any person acquainted with the facts of the case, so as to dissuade him from disclosing such fact to the court or to the IO. These reasons would commonly apply to any person arrested on charge of crime, whereas the grounds of arrest would be required to contain all such details in hand of the IO, which necessitated the arrest of the accused. Simultaneously, the grounds of arrest informing in writing must convey to the arrested accused all basic facts on which he was being arrested, so as to provide him an opportunity for defending himself against custodial remand and to seek bail. Thus, the grounds of arrest would invariably be personal to the accused and cannot be equated with the reasons of arrest, which are general in nature.
My lord, kindly allow me to place one judgment.
No, please.
Yes.
Which one?
My lord, this judgment is very bulky. That is why I have xeroxed only the relevant paragraph, my lord. The lordship may kindly see the page, para 371. Vijay Mandalal. 371. May I read, my lord? The next issue is whether it is necessary to furnish copy of ECIR to the person concerned apprehending arrest or at least after his arrest. Section 19 clause 1 of the 2002 Act postulate that after arrest, as soon as may be, the person should be informed about the ground for such arrest. The stipulation is compliant with the mandate of Article 22 clause 1 of the Constitution, being a special legislation and concerning the complexity of the inquiry investigation, both for the purposes of initiating civil action as well as prosecution. Non-supply of ECIR in a given case cannot be faulted. The ECIR may contain details of the materials in possessions of the authority and recording satisfaction of reason to believe that the person is guilty of money laundering offense if revealed before the inquiry or investigation required to proceed against the property being process of crime, including to the person involved in the process or activity connected therewith may have deleterious impact of the final outcome of the inquiry investigation. So long as the person has been informed about the grounds of his arrest, that is sufficient compliance of mandate of Article 22 clause 1 of the Constitution. Moreover, the arrested person before being produced before the special court within 24 hours or for that purposes of remand, on such occasion, the court is free to look into the relevant records made available by the authority about the involvement of the arrested person in the offense of the money laundering. Para 372. In view thus, supply of ECIR in every case to the person concerned is not mandatory. Your lordship may kindly see the last line.
Mr. Form, tell
Yes,
me,
my lord, here.
ECIR is different. ECIR is something like it's more like it's a form of a charge sheet.
No, it's an internal document of the ED, my lord.
Yes.
Enforcement Case Information Report. What my learned friend is referring Vijay Madan Lal judgment, your lordship will appreciate.
My lord, here.
Just for a moment. That matter was challenging the various of the PMLA Act, various provisions of PMLA Act, and which is referring section 19. Their PMLA Act, Honorable Supreme Court interpreted that the grounds of arrest has to be informed. Now that was being taken up in Pankaj Bansal's case, where Honorable Supreme Court have given the judgment, where Honorable Supreme Court has said that yes, the grounds of arrest, a person has to be satisfied under section 19. Who are the person? Authorized officers. It means that are senior officers. So, as per section 65 of the Act of CRP of the PMLA Act, it says that the arrest, seizure proceedings of CRPC will be followed as far as PMLA is concerned. That's why Supreme Court said in Pankaj Bansal, yes, Vijay Madan Lal judgment is saying nothing wrong. It is saying that you can be arrested, ED can arrest provided there are grounds of arrest to the satisfaction of the authority that is under section 19. Now in Pankaj Bansal, Supreme Court said that yes, grounds of arrest has to be satisfied and grounds of arrest has to be given in light of the constitutional bench judgment. That is what that issue is no more res integra, because what my learned friend is saying in trial court also, that the argument was very flawed, legally flawed, that Pankaj Bansal judgment and Prabir Purkasa judgment is not applicable in our case and even Dhyan Kumar case.
Because 3 judges has decided that grounds of arrest has not to be given. A legally flawed argument. Kindly see Pankaj Bansal judgment, Your Lordship, which I have given. Para 15.
Where?
Pankaj Bansal judgment. The page number same or no? Para 15.
Para 15.
At this stage, does it start with at this stage? It will
Yeah,
be,
para 17. Yes.
there is a problem, Your Lordship, with PDF and all. At this stage, it would be apposite to consider the case law that does have relevance to these appeals and the issue under considered. In Vijay Madanlal Chaudhary, a 3 judge bench of the court observed that Section 65 of the Act of 2002 predicates that the provisions of Criminal Procedure 1973 shall apply insofar as they are not inconsistent with the provisions of the Act of 2002 in respect of arrest, search and seizure, attachment, confiscation, investigation, prosecution, and all other proceedings thereunder. It was noted that Section 19 of the Act of 2002 prescribed the manner in which the arrest of a person involved in money laundering can be effected. It was observed that such power was vested in high-ranking official and that apart, Section 19 of the Act of 2002 provided inbuilt safeguards to be adhered to by the authorized officer, such as of recording reasons for the belief regarding involvement of the persons in the offense of money laundering, and further, such reasons have to be recorded in writing and while effecting arrest. The grounds of arrest are to be informed to that person. It was noted that the authorized officer has to forward a copy of the order along with the material in his possession to the adjudicating authority, and this safeguard is to ensure fairness, objectivity, and accountability of the authorized officer in forming an opinion, as recorded in writings, regarding the necessity to arrest the person involved in the offense of money laundering. The bench also noted that it is the obligation of the authorized official to produce the person so arrested before the special court or judicial magistrate or a metropolitan magistrate, as the case may be, within 24 hours, and such production is to comply with the requirements of Section 167 CRPC. It was pointed out there is nothing in Section 19 of the Act of 2002.
Come to paragraph 18.
My lord. Starting with
The bench in the next paragraph. The paragraph you were reading, the next paragraph.
at this stage, it would have, okay.
The bench in Vijay Madanlal Chaudhary further held. No. You see, neither Vijay Madanlal Chaudhary does not say. Was a case where the paragraph which you are referring as to whether ECI was required to be given or not.
Yes.
But it does not say that the grounds of arrest is not required to be given. It says the grounds of arrest is required to be given as it is the mandate of Article 22(1).
Yes.
So you have to give.
Yes.
Now the question is, in the case of Vihan Kumar, it says that it is required to be given in writing, but that is not an absolute necessity.
Yeah.
You can also give it orally.
Yeah.
But if you are giving it orally, there has to be formulation of the grounds of arrest in your contemporaneous records.
My lord, here, in the present case, there is no violation of Section 50 of CRPC. Section 50 and Article 22. There it says that grounds should be communicated to the accused. That one, it is not necessary that it should be in written. Oral, it should not. It is not necessary. That written should that it has not written that it has not given that it should be given in written. Oral explanation is sufficient. Oral explanation is sufficient. If the grounds is explained in the language he understands. That part we have done. Secondly, in the para 18, that in the Vahan case, in that para 18, it says that it should be formulated. The
And
grounds.
maintained in
Yes, in
contemporaneous.
the CD, I have relied on the first para and the
Para
second
one.
para. Yes.
Para
that
one.
incident
Para one does not
and-
say anything.
So, and the case, his case has been registered under section so and so. That against that section, he was arrested. So why he was arrested, it has been explained, my
Mr.
lord.
Counsel, you don't arrest person. You don't arrest person because you register it. You arrest person because you need him for interrogation. You need it for investigation. And if you don't arrest him, these are the consequences which will befall. Isn't it the reason why you arrest somebody?
My lord, kindly see the entry which he is referring. Kindly see that entry, very surprising. 15:30 hours. Prepared arrest and seizure memo. Right? Kindly, sir, kindly. 15:30 hours, entry number 3. PS, prepared arrest and seizure memo. Now prepared proper arrest memo of the 2 accused persons, so and so. Presence of an available witness and also intimation has been given to the relatives of the accused persons about the grounds of their arrest. Full stop. Encloses annexure. Annexure, your lordship, serial number 8. My time of arrest is 19/5/2024 at 15:40. 15:40. So they have arrested me subsequently after that elapse of after 10 minutes. So as per their entry, if your lordship will see that enclosure which he is referring, there is that there is no grounds of arrest, only one reason. Tick. So that means he cannot justify even from the entry that there was a grounds of arrest formulated. Because your own record says 15:30 you prepared the arrest memo, prepare arrest and seizure memo. Now prepare proper arrest memo of the 2 accused. Proper arrest memo means that one. Kindly see that. Can I have it, please?
Yes.
Sir? Yes. Annexure P3. Okay, hard copy then. Kindly see the entry. See the entry 3, 15:30 hours.
Where?
Pardon?
Where? Page
Page 56.
56. Okay, arrest.
Now see, kindly see the entry number 8. The arrested person, after being informed of the grounds of arrest and his legal rights, was duly taken into custody on 19th of May 2024 at 15:40 hours at North PS jurisdiction. Full stop. Kindly pause here for a moment. Now kindly see whether there is any corresponding entry of 15:40 that I was being arrested
Yes.
in the case diary.
Left for Woka.
15:40 I left for Woka.
Yeah.
So there is no entry that I was being arrested at 15:40. 15:30 says that prepare arrest and seizure memo. Now prepare proper arrest memo of the 2 accused persons, so and so, presence of available witnesses and also intimation was given to the relatives of the accused persons about the grounds of their arrest. Encloses annexure. That annexure, what my learned friend is referring is the arrest court surrender form, this one, which is annexed in the writ petition, in the petition. Where is the formulation of ground? Where is the entry of ground? Yes, yes.
And another thing, if you kindly see 15:30,
Yes, ma'am.
now prepare arrest memo
Yes.
of the 2 accused persons in presence of available witnesses, and also intimation has been given to the relatives of the accused persons about the grounds of arrest. Now, is there anything said in the CD that you have intimated the person accused of the grounds of arrest?
It is already mentioned in para 8, my lord, in the arrest memo, that court surrender form, my lord.
In the CD, you have to mention, don't you think so? Has been given to the relatives of the accused persons about the grounds of arrest. So you have informed the relatives about the grounds of
No,
arrest.
my lord, it was informed to the accused in presence of witness, my lord.
No, kindly
See,
say.
in
Prepare the
presence of-
so-and-so of the 2 in presence of the
Yes.
available witnesses, and also intimation has been given to the relatives of the accused persons
Yes, my lord.
about the grounds of arrest.
Yes.
So you have not informed the accused of the grounds of arrest.
No, my lord, while it clearly says that it was given in presence of witness.
No, kindly see.
That means when the
In
accused was there,
presence of available witness and, you have used the word and. Also, intimation has been given to the relatives of the accused about the grounds of arrest.
yes,
Where is it mentioned in the CD that you have informed about the grounds of arrest?
my lord, when this was intimated to the relatives, accused was also present, my lord.
Mr. Form, kindly appreciate one
Yes, my
thing.
lord.
If you are so particular in mentioning everything, what stopped you from informing, writing in the CD that you have informed the accused of the grounds of arrest?
That specific word has not been used, but by reading in the line, my lord, we can understand that my lord say.
Because when you, and more particularly, when you have stated that it was informed verbally,
Yes,
you should have written more particular that you have been informed verbally. Normally, it is to be written in writing, but you can still go by verbally. But then the records has to show that it has been informed verbally.
your
And
lordship,
formulated grounds of
my
arrest.
lord, my lord, your lordship may kindly appreciate, my lord. By reading
Okay.
this, your lordship may kindly
Appreciate
appreciate.
means no. I'm coming back in 5 minutes. We'll pass the order.
Obliged.
You know, Tom?
In the court staff has not come, my lord, we appreciate that in the arrest court surrender form,
And Mr. From where is the Dhyan Kumar judgment again?
I've already placed before you, my lord.
Got it, got it. I think, no. Where's the Dhyan Kumar judge?
given yesterday only.
You have given it, but where is it? Now, Mr. Form, you kindly give more interest on this aspect. Dhyan Kumar.
I anticipate what is coming from, but that has been negated by the Supreme Court, my lord. Paras 16, I suppose, my lord.
You don't come up with your paragraphs. Your paragraphs doesn't match with us.
I'm surprised. I also got the same thing, but it is in soft copy. How a printout is different, I don't know.
You kindly don't refer to paragraphs. Start with the first line of the paragraph. Hey, yesterday I saw one thing. Where is that? Let me come back.
May I please, Lordship, before your Lordship pass the order, my Lord, kindly allow me to clarify one point. In regard to what is ground of errors, my Lord, it is stated, your Lordship may kindly see the petition, the bail petition, page number 20. The page number 20, only the relevant sentence, my Lord. 1, 2, 3, 4, 5, 6, 7, 8, 8 sentence, my Lord. This reason, the Lordship has seen, this reason would commonly apply to any person arrested on charge of a crime, whereas ground of arrest would be required to contain all such details in hand of the investigating officer which necessitated the arrest of the accused. The details. Then the details has been explained in the city, my Lord. The details. Here it clearly says that details in hand of the investigation officer which necessitated the arrest of the accused. And the details has been explained in the CD, that paragraph which I have referred, my Lord. So my submission.
Don't worry, I'm going to quote that judgment, that paragraph in my order.
Yes.
Okay,
Your Lordship,
enough. Let me read that, ask the order. Don't spoil the time. There's another matter, no, where is that other?
criminal revision.
Where is it? Mr. S. Borgohain, learned counsel appearing on behalf of the petitioner. Mr. E. Tivafong, the learned public prosecutor, Government of Nagaland. You are appearing, Mr. Sophie?
My lord, I am assisting the prosecutor.
Okay. You are appearing for the
Victim.
victim,
Yes, my lord.
and as well as Mr. A. Sophie, the learned counselor, who represents the, it can't be the victim is dead.
The complainant.
The complaint, the complainant. First, both the proceedings are relates to the arrest of the petitioners. Both the proceedings relates to the legality and validity of the arrest of the petitioners. And as such, they are taken up together for disposal by this common order. First, the materials on record reveal that on, what is the date of filing the FIR? That on 19/5, na?
Yes, my lord.
19/5. 19/5/2024, an FIR was filed by one Tezavizo B. Misalho before the officer in charge of the North Police Station, Kohima, alleging inter alia that an untoward incident happened on 18/5/2024 at Phulbari bus stand / taxi stand opposite to Oking Hospital at around 4:40 p.m. It was also alleged that the incident involved the petitioners. Here we are both the petitioners here.
Pardon, my lord? No, only one.
Whom?
A1, accused one. That is, what is that? Spelling that? Nizosito Hiri. Other one has already been granted bail. A2 has been granted bail.
He's gonna.
He has already out.
It was alleged that the incident involved the petitioner and one Kerisoni Urio of Kohima village, which led to the hospitalization of the father of the complainant at ICU Oking Hospital, and subsequently he succumbed to his injuries on 19/5/2024 at around 3:25 a.m. It was also alleged that the complainant was also assaulted by the said two persons. First, on the basis of the FIR filed, a case was registered being case number. Why don't you give type copies of these? It is very difficult to. Case number. What is this case number?
GR.
What GR? GR cannot be
Case
the
number
case number.
45 of 2024.
Not PS case number 45 of 2024.
Not was registered being case number, not police station case number 0045/2024 under sections 352, 323, 325, 302 and 34 of the Indian Penal Code 1860 (IPC). Full stop. The FIR was registered after a general diary reference entry number, after a general diary entry being made on 19/5/2024 at 11:30 hours. Full stop. During the full stop, Mr. Efom, the learned PP, had produced the case diary pursuant to the directions passed by this court on 10/4/2025. From a perusal of the said case diary, it is seen that at 11:40 hours, the said case diary was opened. Stop. Was opened after being endorsed by the officer in charge, by the investigating officer, after being endorsed by the officer in charge of the North Police Station. In the first entry, in the first entry of the said case diary, the investigating officer records about the incident as well as taking note of and taking the initial statement of the victim's son. It is also mentioned therein that after the registration of the FIR, and the case being endorsed to the investigating officer, the investigating officer visited the Sechu Jubja village at 12:20 hours, wherein the house of the deceased was located, and conducted certain legal formalities. Full stop. The most important For the purpose of the instant application, what is important is the entry number Roman 3, which was prepared at 15:30 hours. And in the 15:30 hours, wherein in the synopsis entry, it is mentioned as inverted comma, prepare, arrest, and seizure memo, inverted comma, close. In the said entry, it is mentioned as follows. Now, comma, prepare proper arrest memo of the two accused persons, Nidzosetu Kire and Kire Sutuno Uri, take their names properly, in presence of available witnesses, and also intimation has been given to the relatives of the accused person about the grounds of their arrest, bracket, open and closed as annex, des, bracket closed. It further reveals from the entry number 4 that at 15:40 hours, the investigating officer left for Woka along with the two accused persons and the North PS personnel and the DEF, all caps, personnel for Woka PS for safety and security of the two accused persons, and also to avoid law and order situation due to hue and cry from the public of the deceased village and range. At this stage, this court further finds it relevant to take note of the arrest / surrender, court surrender form, wherein it is mentioned, wherein in the column, date, comma, time, inverted comma, date, comma, time and place of arrest / surrender as 19/5/2024, time 15:40 hours, GD number 03/2024. It is further pertinent to mention serial number 8 of the said arrest / court surrender form. This entry being very pertinent is reproduced herein under page 56 of Pabo. Aru eta jegat ase bhalke dekha napai jodi এই page 49 trial court record করিছে এটু গুটেটো আনি দিছে হ্যাঁ the arrested person is so and so is so and so এই বস্তু এই যোনখিনি কোট কৰা আছে এইখিনি হা নীলা দিমাগ কৈ দিছো পেজ 49 further finds it relevant that there is a reasons that the reasons necessitating the arrest was informed to be, inverted comma, to prevent the accused persons from committing any further crime, inverted comma, close. First. Next. It is also relevant to take note of that on 25/2024, the Judicial Magistrate First Class Woka passed an order taking due notice that the petitioner, along with another, was arrested and produced before him. Him or her?
Her, Your Honor.
Her, before her. In connection with Kohima North PS case number 45/2024, which corresponds to GR 83/2024. And the reasons why the said accused persons were produced at Woka and not before any judicial magistrate before whom, under whom Kohima North PS is situated. The petitioner along with another, by the order dated 25/2024, was sent to 15 days of judicial custody. The record further reveals that the charge sheet have been submitted in respect to GR case number 83/2024. When? Any idea? Will be here in the case diary.
16/8/2024. 16/8/2024.
On 16/8/2024. Before whom?
District Assistant Judge Kohima.
No, yeah. So you submitted the charge sheet before some magistrate, no?
Yes.
Before the
Chief Judicial Magistrate.
Kohima.
Yes, my lord.
Before the Chief Judicial Magistrate Kohima. And thereupon, as the offense opined in the said charge sheet, was under section 290, 352, 323, 325, 304/34 of the IPC. The learned Chief Judicial Magistrate Kohima committed the said case to the learned District and Session Judge Kohima, before whom the said case, being GR case number 83/2024, is presently pending. The record further reveals that a bail application was filed by the petitioner herein before the learned Session Judge Kohima, seeking bail on the ground that the arrest of the petitioner was illegal inasmuch as there was violation to Section 50 of the Code of Criminal Procedure 1973, for short the Code, on the day on which the petitioner was arrested along with another. In other words, the challenge to the arrest of the petitioner is on the ground that there was no ground of arrest grounds of arrest intimated to the petitioner. First, the said bail application, which was registered as IA brackets CRL dot bracket close 54/2025, was rejected by an order dated 4/4/2025 by the learned Principal District and Session Judge Kohima, Nagaland, hereinafter referred to as the learned trial court. It is under such circumstances the petitioner initially filed the application by invoking the supervisory jurisdiction of this court under Article 2 to 7 of the Constitution, which was registered as CRL revision number 6/2025. As a matter of abundant caution, the petitioner had also filed a bail application under section, what is that? 483 of the Bharatiya Nyaya Suraksha, whatever it may be.
BNSS.
For short, the BNNS or BNSS. In the backdrop of the above, let this court take note of the respective contentions of the parties. Mr. S. Borgohai, the learned counsel appearing on behalf of the petitioner, submitted that did we have a constitution? That a reading of section Article 22(1) of the Constitution clearly stipulates that no persons who is arrested shall be detained in custody without being informed as soon as may be of the grounds for arrest Full stop. He submits that this constitutional provision had been percolated to the code in the form of section 50. What is 50A?
Informing the relatives of the.
We are not gone to the relatives. We are on 50. Of the code. What is the code of civil criminal procedure? Let me shorten it and you want to make it long.
That's why I told the 50A also.
Not necessary. One nominated person. No, because here the nominated person, they have done it.
No, that also not been done. Anyway,
Percolated to section 50 of the code. Now, what is the parameteria?
pardon, madam?
Section 50 parameteria to BNS.
It will be 47. It is 47.
Which is now section 47 of the BNSS. He submits that the grounds of arrest was never intimated to the petitioner. And as such, the arrest so made of the arrest of the petitioner is illegal. The learned counsel submits that if the arrest is illegal, the question of remanding the petitioner to the judicial custody and which have been done from time to time is also illegal. In that regard, the learned counsel referred to the judgments of the Supreme Court in the case of Pankaj Bansal versus Union of India and others, reported in 2024 7 SCC 576, semicolon. Prabir Prakash versus State, bracket NCT of Delhi, bracket close, reported in 2024 8 SCC 254, as well as the recent judgment of the Supreme Court in the case of Vihan Kumar versus State of Haryana and others, reported in 2025 SCC Online SC 269. Full stop. Per contra, Mr. Ifong, appearing on behalf of the state of Nagaland, the learned PP submitted that the petitioner herein was duly informed about the grounds of arrest. He submitted that the information so given to the petitioner was given verbally. As regards the maintenance of contemporaneous records, he submitted the entries made at serial number 1 was the basis on which the ground of arrest, serial number 1 only, no?
Yes, 1 and 3.
2 cannot be there. 2 is what?
No, 3, 3.
3 is the, you are informing the ground of arrest.
Yes, yes,
The ground of arrest is 1.
yes.
He submitted that the ground of arrest was based upon entry number 1 of the CD, which mentioned about the incident. First, the learned counsels, learned PP further submitted that in the instant case, as the petitioner was duly informed of the ground of arrest, the basic ground on which the petitioner is therefore assailing the arrest does not further survive. Further to that, he, referring to the reasons of the arrest, also submitted that the petitioners were informed that they were required to be arrested on the basis of as to prevent the petitioner from committing any further crime. He therefore submitted that the said was sufficient for, in terms with section 50, read with article 22(1) of the constitution of the code, read with article 22(1) of the constitution. The learned counsel also referred to the judgment of the Supreme Court in the case of Vijay Madan Lal Chaudhary and others versus Union of India, reported in 2023, 12 SCC 1, wherein the Supreme Court had observed that so long the person had been informed about the ground of arrest, that is sufficient compliance of the mandate of Article 22(1) of the Constitution. Anything more?
And judgment Vihan Kumar and the state of Nagaland in that para 13. I have relied on that.
He further relied on the judgment of the Supreme Court in the case of Vihan Kumar Supra, wherein it is mentioned that there is no requirement that the grounds of arrest has to be in writing.
Yes.
It can be verbally also communicated. Anything more?
And 15, para 15, 13 and 15.
15 is that only, no?
Yes.
Sum up is that.
Yes.
I've heard the learned counsels appearing on behalf of the parties and have perused the materials on record. First, including the CD which have been produced before this court. First, in the foregoing, in the previous segments of the instant order, this court in detail have referred to the entries made in the CD. First, the entry number 3, which have been quoted here in above, only refers to preparation of a proper arrest memo of the two accused persons, which includes the petitioner, in presence of available witnesses. It also mentions that intimation has to be given to the relatives of the accused persons about the grounds of their arrest. The CD, the entries made in the CD do not reflect that any ground of arrest was intimated to the petitioners. To the petitioner. What is reflected is the relatives are to be intimated about the grounds of their arrest. This court duly have considered the submission of Mr. E. Form, the learned PP, to the effect that verbally the petitioners were intimated about the grounds of arrest. This court have duly perused the judgment of the Supreme Court in the case of Vihan Kumar Supra. Which particularly deals with what is required when the grounds of arrest are not in writing. First, it is very pertinent to mention that the Supreme Court had observed that the grounds of arrest in all circumstances should be in writing, but in circumstances when it is not in writing, it is required that there should be contemporaneous records maintained in the entries made in the case diary about the formulation of the grounds of arrest. Paragraph 15 and 18 of the said judgment being relevant is reproduced hereunder. In the backdrop of the above law, so declared by the Supreme Court in Vihan Kumar, it is therefore clear that, and in the backdrop of the above law laid down by the Supreme Court in Vihan Kumar, and applying the same to the facts of the instant case, and more particularly to the entries made in the CD which have been produced, there is nothing mentioned about formulation of the grounds of arrest on the basis of which the petitioners were intimated about the grounds of arrest. Next. This court further finds it relevant to take note of the submission of Mr. E. Form to the effect that in the reasons of arrest which were provided to the petitioner, it was categorically mentioned that on account of to prevent the accused persons from committing any further crime, he therefore submitted that these can very well be taken as a ground of arrest duly intimated to the petitioner.
No, that is the reason, my lord.
I
My
know
lord,
that.
yes.
Then how do you say, why you are mentioning about this then? You were only saying this.
Yes, my lord, that regarding that the ground of arrest is, I have already mentioned that paragraph.
Now that I've looked into.
Yes,
This reason of arrest, you don't want to press this.
yes, my lord. Yes, my lord.
Now he further submitted he submitted. Line to anyone? No, sir. Let this court now take up the other submission of Mr. E. Form. That the reasons of arrest were duly intimated to the accused persons in writing, which was to the effect to prevent the accused persons from committing any further crime. In the opinion of this court, the reasons of arrest and grounds of arrest are two completely different things. And this very aspect of the matter have been dealt with by the Supreme Court in the case of Procastus Supra, and more particularly at paragraph number 48, which is reproduced herein under. From a perusal of the above paragraph, it will be seen that the reason of arrest cannot substitute the requirement of Section 50 as well as Article 22(1) of the Constitution, inasmuch as the grounds of arrest are personal to the accused and wherein the accused is being informed of all the basic facts on which he is being arrested, so as to provide him an opportunity of defending himself against custodial remand and to seek bail. Taking into account the above, it is the opinion of this court that the ground of arrest was not intimated to the petitioner as is required under law. The verbal intimation to the petitioner as submitted by the learned counsel for the learned PP cannot be substantiated unless there is a formulation of the grounds of arrest in the contemporaneous records, which is not available. Considering the above, the arrest so made of the petitioner on 19/5/2024 at 1540 hours has to be declared to be illegal. This court further finds it relevant to take note of the judgment of the Supreme Court in the case of Bihan Kumar, wherein the Supreme Court observes that if the arrest is vitiated, the person arrested cannot remain in custody even for a second. Considering the above, this court is of the opinion that the petitioner herein is entitled to bail. Accordingly, this court grants bail to the petitioner in GR case number so and so, subject to the following terms and conditions. To how much? 30,000? 30,000? Like one security?
One local security.
One local security. And he has to appear in every date.
Yes.
And it is Rakesh Polo hetu sailubo. Rakesh Polo judgment it did. The conditions in Rakesh Polo. These are stringent conditions.
Your Lordship, kindly return me the CD, my lord.
Oh,
Yes, CD.
the CD so produced is returned to Mr. Ifo. Just give me a photocopy of page number 3, huh? There might be some mistake committed by them.
CD, from the CD, my lord.
No, only page number 3, I do that entry 3, because
No, I have extra copy.
okay, reconcilable, huh? And then he will return it to you. Now, the copy of the CD is not given to the accused under 207.
No.
No.
So therefore, this entry will be only put and it will be returned to you.
Okay,
Huh? You
okay,
take
my
it.
lord. Much obliged.
Obliged.
এই ৰাকেশ পলত যোনকেইটা আছে everyday appear কৰা যোনদিনা appear কৰিব এইটো and the trial is what? Do the trial as soon as possible.
Yes, my lord. Do they also fix for
Evidence.
evidence, my lord?
Hmm?
Do they also fix for evidence?
Go ahead. don't delay it
Yes.
or anything.
But
And I have said that you will unnecessary adjournment should not be allowed. Let the trial be completed. Yes. Because one thing good for them for you is he exercised 227 also. 483 I can't direct. But when I'm exercising 227, I can put that word. That is expeditious trial.
Much obliged, my lord.
For motion from the supplementary cost list, item number 12.
For your file it's for extension.
yes, Lordship.
That day I passed an order. Where is that? That day I passed and some IA. Passed a similar order to that effect. In the case of Luciana, I'll give you 6 months time.
Yes.
Okay,
Yes.
6 months time. And the other contempt is there.
Yes, your lordship. It's been
We
listed.
drop the contempt now.
Yes, your lordship.
Because if I'm granting her 6 months, then that contempt cannot remain.
Yes, your lordship.
So drop that contempt. And there should not be normally directions against this chief secretary. There's a contempt. Bring the contempt. Contempt case along with this. Today is it listed.
Item 2.
Yes, your lordship.
Item 2.
There is a lawyer, what was her name? That day she was doing LHOUSINO.
Rosino.
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 I don't want to pronounce wrongly. Very difficult with these different words. So she has an order, exact order which I'll pass. Now today is, what is that date?
11.
11, nah?
Lordship.
So let them complete it by 10th of October. 10th of October. Huh? Completed by 10th of October. So that I allow it. Isn't it order pass cruise? Huh? And then he was taking into account the order passed in IA number here. So he was to write that order. Can you is she available today? Can you get that order? We'll take it up at 2. Pass that order. I'll ask this my person also to find it out. Because I want to pass that order similar to what it is, and you should know it also. So I'll pass, because then what happens, I'm giving this with effect from the date on which you are entitled to.
Yes, your lordship.
I think if I'm not wrong, your lordship, I think that
That another order I have passed.
yes,
No, in that case, this was an IA for which an
extension of time
extension was
sought.
sought. You were there, na?
No, Tipa, my colleague Tipa was there.
He also has it.
Yes.
So if you can get hold of that order, it has been already uploaded.
Yes,
Just get hold of it by 2 o'clock.
lordship,
Yeah?
lordship,
We'll take it up at 2 and pass that order
lordship.
and then drop this contempt. But you have to do it by 10-11. 10-11. 10-10. Okay.
Obligement.
For admission, item number 1.
May I please, my lord? Lordship, in this matter is handled by my colleague, additional IG V. Shokhe, your lordship. She is not keeping well, your lordship, today. She is not keeping well, my lord, and therefore
Okay.
I'm seeking adjournment on her behalf, your lordship, if.
But you have filed the affidavit.
Yes, state has filed affidavit, my
You
lord.
want to file reply?
Lordship, we have filed the reply.
They
And
filed when?
today, Lordship.
They filed the affidavit today.
Yes.
They filed the affidavit on 11th. 11-4 they filed the affidavit, no, who paid the cost? Or
I
you?
paid the cost, Lordship.
Oh, you paid the cost of it?
Yes.
Okay, okay. Now
But
please,
Lordship, on third, when the order was passed
Hmm.
imposing the cost,
Hmm.
there was some discrepancy in the sense that it is not clearly mentioned about to whom it should go.
Oh.
So if Lordship.
I will
makes
direct this cost
clarification,
to be deposited in your welfare fund, na?
High
you have
Court
a
Bar
welfare?
Association, yes,
High Court Bar Association?
yes,
Will put it.
Lordship.
So you then use it by yourself.
I have taken out from my pocket and then it is coming to my account.
Uh-huh.
And incidentally, Lordship, the name of the petitioner, it is in Ao, Rongsen Kala. Rongsen means wealth, Kala means possessed. So the possessor of wealth has been again become loser by 10,000 rupees. She is not in a position to possess the property.
Mr. So-and-so, the council submits that Mr. Ms. V. Sukri, the learned additional AG, is not well, and as such, the matter may be adjourned to some other date. Full stop. This court have also heard the learned counsels and also have perused the materials on record. And I have also perused that the pleadings are complete. Full stop. Considering the above, this court admits the instant writ petition. Full stop. And directs the writ petition to be listed for hearing in the second week of May 2025. Full stop. This court, full stop. Further to that, it is also noticed that on the basis of an order passed on 3/4/2025, the petitioner had deposited an amount of rupees 10,000 as cost. Full stop. The registry is directed to disburse the said amount of rupees 10,000 to the advocates,
Welfare Fund, High Court Bar Association.
to the High Court Bar
High
Association,
Court Bar Association. will be better.
Kohima. Is it High Court Bar or Gauhati High Court?
High Court Bar Association, Kohima.
Kohima, who shall use it for its welfare, who shall use it for its welfare activities. You do whatever you do. It is something like, that day I was reading a news, Justice, Mr. Kapil Sibal had at the time when he was campaigning in the elections, he said that we'll have a coffer of 60 crores through the CSR. Because now the companies have to pay, of which he have already done
It's also
46.
circulated in the social media.
He have already got 46. He said another 16 I'll get it done, and we'll ask the government to give us another 60. Thereby we'll have a coffer of 120. So with a coffer of 120, you see, the lawyers do not have something to fall upon
Source of
later.
income.
The source of income is there, but nothing to fall upon once they are not in a position to practice. So you should do also something. You have big clients.
We are struggling.
Huh?
It's a small bar and then it's in a nascent stage.
You
trying our
have
best.
a small bar, and which is also of the small bar you have 3 bars.
Yes.
Obliged. No, but it's my. I mean, so where is it?
For motion from the supplementary cost list, item number 12.
Please, Your Lordship. Kindly allow me to mention here in item number 9,
No, no,
Lordship.
we'll have it later. We'll mention it.
My lord, lordship, I think your lordship was asking this particular order. If I'm not wrong.
No, this I,
Yes, yes, this I.
yes, I've got it.
Okay, lordship.
Your name, you put it, huh? Put her name. Six months.
Lordship.
Now the petitioner is retiring when? What is the name of the petitioner?
Sokuluriga.
Hmm?
Sokuluriga.
Where do I find in the list? In the list at page 13, page 13, yeah, page 13. Real number. Yeah. Serial number. 7, na? 7. Is it the name? Suzuki Nika.
Yes, yes, yes.
Yes, time. You completed almost 32 years, na?
Yes, your lordship.
You approached so soon.
Lordship, I've approached this honorable court after completing 30 years.
Huh?
I've come before this court after completing 30 years.
Immediately you have come. No, before 10th of October. With effect from 26/3/2023. Just change the name of her name. And where the contempt? Miss so-and-so, the learned counsel appearing on behalf of the petitioner. I've also heard Mr. N. Angami, the learned counsel appearing on behalf of the respondent number 1, and Mr. Moaim.
My lord, my friend,
Two and three.
Jamomi is for respondent number 2.
You are for?
I am for respondent number 3.
VG Momi is not here. I've seen him. Mr. VG Momi for respondent number 2 and Mr. Moaim Chin for the respondent number 3. First, the instant contempt application has been filed alleging willful and deliberate violation to the order dated 28/11/2023 passed in WPC number 75/2023, wherein this court had directed completion of the entire regularization period of 1 month. The learned counsel appearing on behalf of the this court, by an order passed in today, by an order dated today, put today's date, 11/4/2025, in IAC number 49/2025, had extended the period mentioned in the order dated 28/11/2023 to 10/10/2025. First, considering the above, this court is of the opinion that the further proceedings of the instant contempt application would not cannot be proceeded with. Accordingly, the contempt proceeding stands dropped. First, the petitioner would have liberty to approach this court if the directions contained in IAC number 49/2025 arising out of writ petition number 75/2023 is not complied with.
For admission, item number 3.
May I please, Your Lordship? Your Lordship, I have received instructions here that this is a case for regularization, and there's been a vacancy has arisen in the department due to the retirement of one MTS. Now, petitioner being the senior most in the work charge employee, his case is being considered by the department.
So you bring it on record by filing an affidavit, or you file, or you have regularized? So whenever a vacancy arises in the year 2025, you're going to regularize the petition.
Vacancy is already there. Vacancy has already occurred, Your Lordship, and petitioner being the senior most, his name has been forwarded to the government for regularization. As per the letter dated 19th March.
We complete it?
Yes, Your
Dispose it
Lordship.
off?
Lordship, but there is one submission I would like to make that if this court can pass an order that this is just a forwarding letter, and so yes. And there is another submission, Lordship.
Madam, wait, madam, you put this thing on affidavit.
Yes, your lordship.
Miss A. Aimi, the learned counsel appearing on behalf of the respondents, submits that she have been instructed by the communication dated 2nd of April 2025 to apprise this court that the proposal that the petitioner, being the senior most casual multitasking staff at the district horticulture office Zunavato, the proposal to regularize the services of the petitioner have already been sent to the government on 19th of March 2025. He therefore the learned counsel therefore submits that the writ petition can be disposed of on the basis of the said communication. The learned counsel appearing on behalf of the petitioner, however, submits that the said aspect be brought on record by an affidavit filed by the concerned respondent authorities, inasmuch as the instruction is only on the basis of, it is only an instruction issued by the Director of Horticulture. Taking into account as the said instruction was placed before this court keeps on the said instruction on record and marked with the letter X. The respondent authorities, through its concerned officer, shall bring on record their stand by filing an affidavit within 2 weeks. Mr. Counsel, if I put it on record and make it an X, then they are bound because it becomes a part of the record. You could have had the disposal today.
Lordship.
For admission, item number 4.
My blessed lordship.
Huh?
Lordship, here I'm here to receive my instruction, so sometime may be granted. This instruction, lordship. I'm here to receive my instruction, lordship.
You have not received an instruction.
Lordship.
Ms. So-and-so, appearing on behalf of the government respondents, submits that the instructions are awaited. She therefore submits, she requests for 3 weeks' time to obtain the necessary instructions. Lists the matter again on 23rd of May 2025. The respondents are directed to bring on record their stand by way of filing the affidavit on or before 16th of May 2025.
I would like to.
For admission from the supplementary cost list, item number 14 and 15.
May I please, your lordship? Lordship, am I appearing through VC?
Yes.
The principal counsel for the appellant, he's disposed, lordship.
Huh?
He's indisposed, lordship.
Who?
The principal counsel for the appellant. With the consensus of the respondent, principal counsel.
The respondents have not given any consent, as he says on the face. See, smile, he is not giving. Okay. Mr. Devnath is not there, so obviously none appears. We dismiss this application for default. Madam? Isn't it? Dismiss for default.
Description of
Mr. V. Devnath, the learned counsel appearing on behalf of the applicant, is indisposed. So taking into account the above, list this matter on 12th of May 2025, it is observed that there has been a delay in disposal of this application for condonation, which is being pending since 2024. And as such, and the said delay is prejudicing the claimants. Considering the above, there shall be no adjournment on the next date. The applicants are directed to take appropriate steps so that their counsel are duly represented on the next date so fixed.
Obliged, Your Lordship.
For orders, item number 5.
Lordship, in this matter, I've completed the new respondent. Notice is yet to be issued. I've completed a new respondent, the notice is yet to be issued. I pray the notice may be issued.
You have taken steps?
Yes, no, not yet. Notice has not been issued.
Oh,
Yes.
upon newly.
The newly completed respondent, sole respondent.
Okay. What is the case about?
For
What is the direction?
the direction is to file a representation before the deputy commissioner. The deputy commissioner to take a verification.
State that the deputy commissioner, upon such verification and a report that may be submitted, will take appropriate in accordance with law.
The verification has been
You
done.
file a representation.
Yes, I did. The verification has been done, just that the
And
report is
he has
sitting.
not disposed of.
No, not yet.
I have not taken steps.
No.
Okay. You have been pleaded, na?
Yes.
Also. It is seen from the records that on 1/4/2025, this court had impleaded the present deputy commissioner, Sumiki Dama, as the respondent. However, it is seen that no notice have been issued upon the newly impleaded respondent. Issue notice upon the newly impleaded respondent number 4. 4, na?
Sole respondent.
How can they be sole? Upon the newly impleaded, it's a impleadment. Impleadment cannot be a substitution. Anyway, newly impleaded respondent. Steps be taken upon the respondent by way of registered as well as usual within 3 days. List the matter after completion of service.
For orders, item number 6.
You file affidavits.
Yes, my lord.
What is your stand? Why you are not paying?
No, Your Lordship, the payment have started. The payment have started, my lord.
Payment we are making it.
Yes, Your Lordship. We have annexed. In fact, the other parties, other respondents also have filed their affidavit, Your Lordship.
You have already made.
Yes, it has started, Your Lordship.
Okay. It has been submitted. It is seen from the records that the respondents have filed their affidavit in the matter, in the instant proceedings, wherein it has been stated that they have already started making necessary payment of the area salary with effect from 1/1/2015 to 28/2/2015 to the members of the petitioner association. Ms. So-and-so, appearing on behalf of the petitioner, submits that she would obtain necessary instruction and if necessary, and obtain necessary instruction and if so advised, the petitioner would file a reply. Okay,
Yes, Your Lordship.
okay. List the matter again on 9th of May 2025. In the meantime, the affidavit in reply be filed by the petitioner.
Yes, Your Lordship.
For hearing, item number 7.
Yes, Mr. Longkuma, what is your matter?
But this is pertaining to appointment the post of medical career at Animal Husbandry Center, CTB. Despite the appointment order being quashed and set aside by the appellate court, the private respondent is still allowed to continue in service, my lord.
The private respondent?
Still allowed to continue. My lord, the fact of the case is that, my lord, a post of medicine career at Animal Husbandry Center CTB against retirement of one Shri Vihoshe occurred. And against that vacancy, the petitioner was approved for appointment by order dated 6/10/2010. The said appointment approval order was challenged by the private respondent on the ground that he is the landowner. However, based on an agreement of 1972 and an affidavit of 2009, and then the state respondents has earlier writ petition, that is 166 of 2020, they have stated that they have contended that the affidavit was unauthorized. And then what happened was this court, by order dated 24/6/2011 in WBC 166, has directed the state respondents to take fresh consideration.
Fresh
consideration, giving opportunity to both the petitioner and the respondents.
That means the normal process.
Yes. Now, thereafter, what happened as directed by the Honorable Court, the respondent has taken a fresh consideration, wherein the claim of the respondent number 4, claiming appointment on land ownership, was was termed as unauthorized, and the approval of the petitioner earlier issued was upheld. Again, that decision was challenged in WBC number 238 of 2011.
Then?
And this Honorable Court, by an order dated 28/9/2011, has stayed the approval of the petitioner. Thereafter, subsequently, an IAO or CNC was filed, and by order dated 30/11/2011, the interim order passed by this Honorable Court suspending my approval order was revoked. Thereafter, in view of the revocation of the interim order by an order dated 4/14/2012, the petitioner was again appointed based on the approval order.
You were appointed?
I was appointed. Now, again, the respondent number 5 as writ petitioner approached this Honorable Court by filing WBC number 31 of 2012, challenging my appointment as well as the approval order. Now, thereafter, this Honorable Court, by order dated 29/2013, set aside
your appointment,
my appointment order. Thereafter, being aggrieved by the judgment of the Honorable Single Court, the present petitioner have approached the appellate court by filing it WA number 18 of 2013 and WA number 19 of 2013.
Why there are two appeals?
Because there was two writ petition. One was challenging against my approval order. During the pendency of the appeal petition, I was appointed. So subsequently, they have to file another writ petition. So in view of that, there was two writ petition.
First is challenging your approval.
Yes.
The second is challenging your
appointment order.
Your appointment order.
Yes.
Now both were set aside by the single judge.
Yes.
So you went in appeal.
Yes,
Appellate court approved, interfered with the single judge
Yes.
judgment in your favor.
yes, in my favor. And
By a common order dated 26/6/2018.
yes, my lord.
And thereupon you have not been what?
Yes, and then the private respondent is still allowed to continue.
How? Mr. Imchin? No, you are beneficiary. Mr. Imchin, how are you allowing the private respondent when he is having an appointment order?
Lordship, this is a very old case. Lordship, may kindly turn to my to the state affidavit in opposition, Your Lordship. Lordship, may I read page 3, paragraph 4? May I read, Your Lordship? That with regard to the statements made in paragraph 2 of the writ petition, the deponent respectfully states that at a point of time, a box of medicine care at Veterinary Health Center Sitimi under the establishment of Chief Veterinary Officer Kefri arose. Meanwhile, sole application was duly received from the respondent number 4, who was the lane donor for establishment of Veterinary Health Center Sitimi, and the respondent number 3 duly forwarded. Respondent number 3 is the Director of Veterinary Services, Your Lordship, forwarded an application to the State Government for consideration after following the due process. The office of the respondent number 3, Your Lordship, that is the Director.
No, all are understood. The appointment of the respondent number 4 was quashed.
Lordship.
Your basic case is that there is no whisper in the writ appellate judgment that the petitioner should be appointed.
Yes.
That is your case. But why is the respondent number 4 continuing? See paragraph 8.
Lordship, that question of Your Lordship, I think my...
No, you are the government, not them. Where the writ appellate court judgment?
The writ appellate judgment is at page number 56, annexure K. my lord. Paragraphs are para 8, 13, 14, 15, 16, and 17. You read, my lord?
This order of 28/11/2013, by which here the respondent was appointed, was set aside, page 72 of the writ petition. Isn't it?
Yes, my lord.
So when that order is no longer there, on what basis are you paying the respondent number 4? Is the respondent number 4 kept on for other extraneous reasons?
Lordship, that aspect of the matter, I need to take...
That is your basic case in your affidavit, paragraph 8.
Correct, Lordship.
Yes.
Yes.
Isn't it?
Yes, my lord.
How? Read paragraph 8, you are referring to only paragraph 4. Read paragraph 8.
Lordship, para 8 also important. I was supposed to read para 8 also applies.
Please read. That is it. That is what you are saying. Read that.
That with regard to the statements made in para 10 of the writ petition, it is pertinent to state herein that the appellate court by common judgment in order dated 26/6/2018 allowed the writ bills holding that the document dated 7/2/2019 has no legal validity in the eye of the law and set aside in quash the appointment order dated 28/11/2013 issued in favor of the respondent number 4. However, the appellate court in its order does not whisper a word or direct the state respondents to appoint the present petitioner in place of the respondent number 4. Mention may also be made that the office of the respondent number 3 never received any application while seeking for an appointment and for which the respondent number 3 informed the petitioner to submit the necessary required documents. But he never acknowledged or took any steps to submit the necessary documents to the respondent number 3. Moreover, the present petitioner was in deep slumber and does not have any local standing to disturb the appointment of the respondent number 4.
No,
Please delete it.
understood.
Stage.
On what basis are we keeping the respondent number 4? Have we appointed the respondent number 4 subsequently by another order?
No, continues. Continues.
How?
Lordship, will kindly see my affidavit opposition I will submit. Here arises a question where I am the landowner. That is.
No. We are not on those. My question is, after your appointment has been set as illegal, how are you functioning?
That is the only whole issue.
This is after all public money.
Correct.
So you do one thing, you recover all the salary you have given to the respondent number 4 all this while and take it from 2018 and take it and put it in the public coffers.
Lordship, allow me some time. Let me find out.
Nothing
Let me find
the
out.
other. It's such a small matter. How is it pending from 2021?
No, Lordship, since your Lordship is coming in May. Lordship,
I'm not coming in May. I won't come in May. I may not come. I will come in December.
give it as a barter matter and meanwhile.
Partner. For me, this is too small matter.
And
but
then meanwhile.
I keep a partnered matter only when it is required, but I won't keep it there.
Lordship, my affidavit has been filed way back in.
Whatever may be. But the fact remains, unless you have appointed the respondent number 4 by way of any other selection proceedings.
Correct.
If you have not, how are you continuing? And if that officer have allowed, take all his money also. Recover it from him.
Lordship, let me find out. Let me find out the reason.
Who is
And
the-
let
who
me
is the
satisfy your
officer
Lordship.
Officer who is manning the respondent number 4? Who is the officer above? Who is the disbursing
That
authority?
is the
of
district veterinary officer,
Ah,
Caffrey.
so take it from his salary. This money, if they can't get, if you can't recover it from her. We are only concerned to that effect. This cannot happen. When the order has been set aside, how on earth can the respondent number 4 be allowed to continue after 2000?
Lordship, let me have a conference with the concerned officials and let me satisfy your Lordship.
Fantastic. 3 o'clock. 3 o'clock. Consult 20 minutes I'm giving you.
Lordship, allow me some time. Let me have a conference with the officials concerned.
20 minutes that he will take out. If he can't recover it from him, Calcutta High Court in the 25,000 people who were illegally appointed have taken their salaries also.
Correct, Lordship.
So we will be also doing the next.
Lordship, let me find out. Let me find out. I'll find out. I'll find out.
It's a very serious thing. Yes, tell me.
Lordship, just one aspect here is, if my lord will kindly come to my page 9 of.
No, madam, tell me whether you have an appointment order as on date.
As on?
As on date.
I'm still in service, Lordship.
How?
In continuation with the previous
Which have been set
appointment.
Which have been set aside.
Lordship,
If it
And-
is set aside, thereupon is there any appointment order thereafter done?
No,
Then why are you continuing in service?
because Lordship, the department in the previous occasion also, we have taken from the, right from the beginning that
And that has already been nullified. By the division bench of this court, that has already been nullified. Your appointment order has been set aside. You are freshly appointed, that is another aspect of the matter. We are not concerned to that.
that
But
Lordship, that
you have
aspect I
not
don't
been
know.
freshly appointed. So this is in complete violation to the court's order also, division bench courts also. So it is a case of contempt, which we are going to take it suo moto against your veterinary officer, whoever it is, as well as take all the salary what you have got. This is absolutely illegal. These things can't happen. They're very serious.
That is one aspect on the principle of law, Lordship. But here, the issue here is from the beginning itself. From the beginning itself, we have taken the plea that he did not even submitted the
Forget about this.
representation.
We go on the question of qua warranto. We exercise the jurisdiction under qua warranto. How a person is being allowed to continue when there is an order being passed. He will take it that he has brought it only to the attention of this court. We would not give him that relief that he's asking, but we give the relief. Yeah.
And the fact that Lordship, if I'm not in the previous my appointment order, it says that one-time appointment for land owners in the previous writ
We are
petition.
not there. The matter has ended in the division bench.
So on the part of the respondent government,
This is a
Lordship,
very serious thing which has happened.
there is one aspect. Yes, Lordship, I leave it to my Lordship's opinion. That I leave it to my Lordship opinion. One aspect is that if I don't have even one-time appointment, Lordship, the issue comes the place where the veterinary office land belongs to an individual, as my Lord is very clear about Article 371, and in Nagaland, land belongs to an individual. If one-time appointment is not given to me from the beginning itself, these issues arose, and that is why the land where the veterinary office is standing is my land. He is from another tribe.
I'm not on that.
Yes, Lordship.
I'm not on that.
But the factual
But
position,
on the
Lordship.
basis of which the appointment order was given to you have been set aside.
Lordship,
One aspect, Lordship, the petitioner was, the present petitioner's appointment was for 1 year. So in the meantime, when the case was pending, his 1
I am
year
therefore,
period.
Madam, therefore, the question is, let us take it, the petitioner may not have a right to be getting the relief that he should be on the basis of that approval.
Lordship.
Let us take it. But does it mean that there can be a continuation which is in violation of the court's order?
That I have not, that aspect I have not inquired, Lordship, whether there is a fresh appointment or the previous continuation. On my part, I submit before
That
this
is the
honorable court.
basic, that is the basic case.
I have the, I'll have to have
The
the,
entire case is based on Mr. Longkumar, the platform is that only. Then
just a clarification, I have not asked whether
you
there
have
was a
not
fresh
asked me,
appointment.
there is nothing, we'll presume that there is
Ye-
no.
Lordship.
We'll presume there is no. So you take the salary what you have got, and if you can't, we direct the veterinary officer, whoever is in charge, who is the disbursing authority, to pay that amount, and if he can't recover it from her, then the state government will deduct it from his salary.
Lordship,
By this way, something important happens.
I'm very much in agreement with your Lordship, the finding of your Lordship. But Lordship, let me find out. Allow me sometime so that let me find out what is wrong. Or since my affidavit in opposition wasn't filed way back in 2021.
But you knew the matter is.
How?
You knew the matter
what
would
was
come up before this court.
what was going on? I do not know whether they have issued a fresh Appointment order on the basis of the land ownership because there is no dispute about the private respondent.
How can there be an appointment on land ownership basis when the division bench has already stated
Correct,
that the question of land ownership of the respondent number 4 does not arise?
correct,
That, and if you have done so, is it in violation of the High Court's order?
correct, your lordship.
So
Your lordship,
we
correct.
initiate contempt suo motu. Yeah.
Lordship, allow me some time. Let me
Suo
find
motu
out.
contempt.
Bring it to your notice of your
I have
lordship.
already, you have also stated in your affidavit at para 8. Suo motu contempt.
Lordship, let me find out. Let me find out. I'll satisfy your lordship.
I am not satisfied. Yeah, how can this thing go on like this?
Lordship, allow me also to inquire from the petition.
Not
petitioner.
and stop her salary. No salary. Your only salary shall be subject to the outcome of the petition. Yeah. Don't pay her salary. Because the question of paying salary on an illegal order, illegal continuation cannot happen.
Correct. Your lordship
So
is right.
all her salary is stopped and giving you further right to recover during the pendency of the petition. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. Moim Chin appears on behalf of the respondent.
1, 2, and 3.
1, 2, and 3, and Ms. So-and-so, Judge Jimomi, appears on behalf of the respondent number 4. First, the present litigation has a checkered history. First, a post of medicine's career fell vacant in the establishment of the outpost veterinary and A&H office Sitimi town Kifri due to the retirement of Sri Vihoke on 30/11/2012. Full stop. The respondent number 4 filed an application seeking appointment on the basis of land ownership. Full stop. I filed an application on 3/12/2009 seeking appointment on land ownership basis. Full stop. The petitioner, the respondent number 4, also submitted representation to the Directorate of Veterinary and A&H Kohima on 9/9/2010 to appoint him to on landowner certificate on the ground that the office in question exists on the land donated by his father. On the other hand, the petitioner herein, on the other hand, the state respondents had approved the appointment of the petitioner against the post. The respondent number 4 thereupon approached this court by filing a writ petition being WPC number 166K of 2010, seeking appropriate directions for consideration of the case of the respondent number 4. This court, by an order directed by an order
28/9/11.
dated 28/9/2011
24/6
in WPC number 166K of 2010.
Its order is 24/6/2011, my lord.
24?
24/6/2011.
6/2011 by then in WPC number 166K oblique 2010. Was of the opinion that the matter required fresh consideration by the respondent authorities, taking into account all the points urged by the parties. And directed the respondent authorities to consider the case of both the petitioner as well as the respondent number 4 by giving personal hearing to both the parties. The respondent authorities thereupon, after hearing, validated the approval so granted in favor of the petitioner. And thereupon, further issued an appointment order in favor of the petitioner. This led to the second round of litigation filed by the respondent number 4, challenging the approval order of the petitioner as well as his appointment order. The writ petitions so filed by the petitioner by the respondent number 4 were WPC number 238K oblique 2011 and WPC number 31K oblique 2010.
2012, my lord.
2012. 31.
Yes, my lord.
31K of 2012. The coordinate bench of this court, by the judgment and order dated 29/2013, allowed both the writ petitions, thereby setting aside the order of approval dated 6/10/2010 as well as the order dated 14/2012 whereby the petitioner was appointed. Subsequent thereto, the petitioner herein preferred 2 appeals, being writ appeal number 18
Yes,
oblique 2018K oblique 2013 and writ appeal number 19K oblique 2013. During the pendency of the said appeals, on 28th of November 2013, the respondent number 4 was appointed to the post of medicine carrier at VHC Sitimi under the establishment of the district veterinary and ANH officer Khifri for an initial period of 1 year with effect from the date of the joining.
That was petitioner.
Huh? This is of yours, no? Respondent number 4. Your appointment order, 28th of November 2013, page 55, isn't it? This is your appointment order, Annexure J.
In my affidavit in opposition.
No, kindly see page 55 of the writ petition.
Yes, Lordship.
Is that am I right? Initial appointment was made on ad hoc basis for a period of 1 year with effect from the date of joining to the post with a condition to be terminable by 1 month notice in writing and subject to regularization through the departmental screening committee. It is further relevant to take note of that the learned division bench of this court, by the detailed judgment and order dated 26/6/2018, set aside the judgment and order dated 29/2013 passed by the learned single judge by this coordinate court by the learned coordinate bench of this court in WPC number 238K of 2011 and WPC number 31K of 2012. On the basis thereof, the order which was impugned in WPC number order, the approval order as well as the appointment order of the petitioner which was impugned in WPC number 238K of 2011 and WPC number 31K of 2012 revived. It is further pertinent to, it is very pertinent to mention that the learned division bench also taking into account that during the pendency of the proceedings, the respondent number 4 herein was appointed by an order dated 28/11/2013, had set aside the said appointment order dated 28/11/2013. The petitioner thereupon intimated the respondent authorities about the said judgment and order dated 26/6/2018 passed in both the writ appeals. The petitioner thereupon followed up with not only a communication that if no appropriate steps is taken, contempt proceedings would be initiated. But I also issued another a legal notice on 24/3/2021. It is seen from the records that the judgment and order passed by the division bench of this court dated 26/6/2018 in writ appeal number 18K of 2013 and writ appeal number 19K of 2013 was not at all adhered to by the respondent authorities. And this very aspect of the matter is clear from the fact that in spite of persistent representation and legal notice, the respondent authorities continued to employ the respondent number 4 without there being a valid and legal appointment order. Full stop. It is under such circumstances the petitioner has approached this court by filing the instant writ petition. This court have also taken note of the affidavits filed by the private respondent as well as the respondent number, private respondent as well as the by the official respondents as well as the private respondents. Full stop. The stand of the official respondents mentions that the order of the learned division bench had only set aside the order of appointment of the private respondent of the respondent number 4 dated 28/11/2013. And further goes ahead to say that there was no specific direction by the learned division bench in appoint the petitioner. First, the said stand so taken at paragraph number 8 of the affidavit of the respondent authorities is completely flawed, taking into account that there was an appointment order of the petitioner, which was set aside by the learned ordinate bench of this court, and the learned division bench having interfered with the learned bench of the court, having interfered with the judgment of the learned ordinate bench of this court, comma, the order of appointment of the petitioner revives. First, the further flaw in the stand so taken by the official respondents is on the question of permitting the respondent number 4 to continue in spite of the order dated 28/11/2013 having been set aside by the learned division bench of this court. First, the allowing the it is the opinion of this court that allowing the respondent number 4 to continue on the basis of an order which had been set aside amounts to allowing the private respondent to continue in a job without any valid sanction in law. First, considering the above, Mr. Moin Chin and the learned counsel appearing on behalf of the official respondents and Ms. Jimomi, the learned counsel appearing on behalf of the respondent number 4, submits that they are not aware as to whether there was a further appointment order made in favor of the private respondent number 4. This court is shocked and surprised at the submission, taking into account that the edifice of the petitioner case based on the fact that in spite of setting aside the order dated 28/11/2013, the respondent's authorities are permitting the private respondent to continue. Taking into account the above, the entire factual aspect, as well as the stance so being taken, it is the opinion of this court that the further continuation of the respondent number 4 as a multi-carrier,
Medicine carrier.
multi-carrier,
Medicine carrier. Medicine
carrier is not permissible unless the respondent number 4 have not been appointed by following the due process. Consequently, this court fixes this matter on 24th of April 2025 Full stop. On which date the respondents herein shall produce before this court as to whether there has been a fresh appointment made in favor of the private respondent number 4 after the setting aside of the order dated 28/11/2013. Full stop. It is pertinent also to observe that in the circumstance, the respondents have permitted the respondents have permitted, the official respondents have permitted the private respondent to proceed on a work without an order of, or without an official or without an order of appointment after following due process, comma, the concerned disbursing officer of the concerned disbursing officer. No, the controlling authority of the petitioner, of the private respondent, has to be blamed. Full stop. Or full stop. This court also duly takes note of that a person had, if there is no fresh appointment order, comma, payment made from the public coffers amounts to payment made without the sanction of law. Full stop. The controlling officer of the private respondent number 4 shall bring on record their stand by filing an affidavit by 23rd of April 2025. List according.
Publish.
Then we'll ask that. Finished.
Probably.